Hello friends, in the series on the income tax cases, today we will discuss a very important case on joint development agreement. The title of the case is Prithvi Consultants Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 470 ITR at page number 37. The matter has been decided by Honorable Bombay High Court and the date of the judgment is 5th September 2023. This case is regarding joint development agreement. In this case, the assessment year concerned are assessment year 56 to 11-12. In the present case, the assessee entered into joint development agreement for the development of his property. In this case, no consideration has been received by the assessee. The developer was not able to perform his contract, and ultimately in the future years the joint development agreement was cancelled, and the assessee also intimated this fact to the department also. During the assessment proceedings, the assessing officer was of the view that since there is a joint development agreement, the consideration written in the joint development agreement has accrued to the assessee, and it doesn't matter whether this consideration has been received or not. In this particular case, no amount has been received by the assessee, and accordingly learned assessing officer calculated the capital gain and taxed it. When the assessee moved to the CIT appeal said that this is not transfer as per section 2 clause 47 and gave relief to the assessee. The department moved to the ITAT again upheld the order of the AO. So the assessee was before the High Court. Now, as far as the joint development agreement is concerned, we have to read three sections by taking them as a whole. Section 2 clause 47 of the Income Tax Act, Section 53A of the Transfer of Property Act 1882, and Section 17 and 49 of the Registration Act 1908. The Registration Act 1908 was amended, and the crux of that amendment was that the document containing the contract to transfer shall not have any effect unless it is registered. But that document will have only the limited purpose of a specific performance or as evidence in the collateral transaction. But that document will not have any effect as far as the transfer is concerned, according to Section 17 of the Registration Act 1908. The High Court also said that in the present case, the ownership with the assessee and the possession at the highest was transferred to the developer only for the limited purpose of the development. So, applying Section 17, Section 53A of the Transfer of Property Act 1882 and Section 2 clause 47, until and unless the document containing the contract to transfer is registered, it cannot be termed as transfer as per the definition of Section 2 clause 47 of the Income Tax Act. So, it cannot be said that the property is transferred and capital gain cannot be calculated. Friends, nowadays we have seen that there are a lot of joint development agreements being done by the assessees. So, this problem arises in the number of the cases, and the doubt arises that in which year the assessee has to pay the tax. Although it is a very complicated issue because the consideration is also received over a period of time when the property is transferred. It is being completed in the future years, and even in the future years sometimes the registration is done at a later stage of time. So this case is very helpful in understanding the concept of transfer according to Section 17 and 49 of the Registration Act 1908 and Section 53A of the Transfer of Property Act. So in this case, the Bombay High Court quashed the addition made by the learned assessing officer on the basis of the joint development agreement. At the end of this video, once again I am repeating the name of the case. The name of the case is Prithvi Consultants Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 470 ITR at page number 37. The matter has been decided by Honorable Bombay High Court and the date of the judgment is 5th September 2023. Thank you, friends.